Today we're talking about Jonathan Major's case. The attorney has published a major part of his defense, so I want to talk about those text messages, I want to talk about the underlying charge, and I want to talk about how common a case like that is for attorneys like us. My name is Marcus Landsberg. I'm a criminal defense attorney who deals exactly with this type of case. Now, I want to say up front, first and foremost, I hope this is not true. What Jonathan Major's accused of is not true, because I don't want anyone to be a victim of abuse. But for the purpose of learning about the court process, let's learn what a criminal defense attorney does in a situation like this. First, the case is not out of the ordinary. The, quote, got too drunk argument on the way home, it becomes physical, end quote, is a common factual scenario. The let me see who's texting you is a common inciting argument. This is basically the beginning of the Chris Brown-Rihanna argument many years ago. It's right there. So let's say as a defense attorney, we get the call, usually from a manager or a handler. More often than not, it's actually from the entertainment attorney who goes through their contacts. And since they're the attorney, they're the ones who get called first to then refer it out to a criminal attorney who does this type of case. And then they screen you to see if that's what you're going to handle. What we want to ask as a criminal defense attorney, number one, is has the defendant, Jonathan Majors in this case, talked to the police yet? It's the most important thing. If he hasn't, is he likely to? Because if he has, and if he has, I'm sorry, what did he say to the police? That's important to us. If he hasn't talked to him yet, our job is to stop them from talking to him. If he has spoken to the police, then we need to run down there, find out what he did say, and see if there's another statement we have to make or something else we have to do to make sure what it is. It's on us to make sure Jonathan Major knows, or whoever the defendant knows, that he has a Fifth Amendment right to remain silent. And if he wants to use his Fifth Amendment, and he should use his Fifth Amendment, what he would say is, I want to use my Fifth Amendment. This is my lawyer. All questions go to him. And that he stops, or you stop there. You don't go past that. Even if they say, okay, but let me just ask you a few. You give them your name. You can tell them your address. But at that point, you stop and you don't go any farther. If he has spoken, we need to know the context. Was it an interview where they took him in a room, read him his rights, and interviewed him by a detective? Was it the first responding police officer came to the scene and got the story from both sides, so he told the person the story in that context? Was it, I'm not telling you anything, but she's the one who made me do it? That's the kind of statement we need to hear. And that's the first step, is to figure out any kind of confessions and to what degree they exist. So once we take care of him not talking about himself or getting that across, then we have to start collecting the information. One, was it reported at the scene? In this case, it was not. It was reported the next day in the morning. Number two, the event happened on the way home from a bar. Number three, it happened in a taxi. And number four, it's being reported there are visible injuries, including a laceration on the neck. The laceration is not good. That's going to be the part that works the hardest against Jonathan Majors and his attorney as they try to say that he's either not guilty or innocent of the entire case. Then what we want to do, and what we do here, is we reach out to her. This is before he gets charged. What we want to do is we want to reach out to her either through him or through a handler. And mainly we have to find out, is she still mad? The way I usually ask that question to the defendant or to his friend or go-between is, do you see yourself getting back together with her, the accuser? That question will usually start the whole narration of a context of their relationship. Who makes decisions, who holds the power generally, what the breaking point is that caused this particular event, whether the event was calling the police or whether the event was a fight immediately before that. If the accuser wants to help the defendant, and I think this is going to play very strong in this case, Jonathan Majors in this case, we will have a much easier time defending the case. But if she doesn't, it becomes having a much harder time, especially with that injury. Here's what I mean. In this case, the attorney has claimed they've collected two statements recanting the accusation in this case. Recant means what I said before, that's not true. Now, in the legal setting, often we'll use the phrase recant to just mean the person no longer wants to proceed the charge, even if the person never wanted to proceed on the charge, or even if they didn't mean to make a statement in the first place. Recant usually means that a purported victim is now saying they do not want to be a part of the case, or that it did not happen, I should say. That whatever happened, it did not happen the way the prosecutor is accusing. Now, in an ordinary case, I would not collect recanting statements. There's a lot of reasons why, but generally a criminal defendant does not want to take witness statements and tie them to those statements too early pre-trial, especially before they see the discovery. But this is a high publicity case, and this case is different. The reason why is Jonathan Majors got a lot of money riding on if he even gets charged or what degree he gets charged to how the procedure goes. So his attorney is doing the right thing, in my opinion, is trying to get this case dismissed as early and as quickly as possible. They tried to not let him be charged. Obviously he was. Now they're trying to get the case dismissed before he ever has to show up for a trial setting. So I understand why they're doing it. We wouldn't do it in a case that doesn't have high publicity, but in a high publicity case like this, absolutely, I think they're doing the right thing strategically with the information that they have. If they have different information, I might disagree. But with the information that we have, I think they are doing the right thing. But yeah, and this is what I said. In this case, the attorney moved exactly right. Now, in a trial, a recant changes a lot of things. In my jurisdiction, it lets in prior events. It lets in prior character about the defendant that may not come in otherwise, that we would never know otherwise. Prior accusations, for example. In this case, if she's recanting and they go to trial, that may come in and I'm sorry, but if New York follows the same law that my jurisdiction follows, and many jurisdictions do. I don't want to say specifically about New York, I'm not sure. For example, there's two people, and I think there's only two at this point, not more have come out, on Twitter who say Jonathan Majors has a history of violent conduct. First of all, hearsay wouldn't come in anyway. But could it come in? Could the people they're talking about come testify about prior behavior if she says this never happened or in another matter, he's not the type of person to do that? In my jurisdiction, potentially it could. And that's a huge difference in a trial if you're arguing against their character versus what had happened in this particular case, for example. Okay, so what can we deduce from the information that we know so far? One, because this happened in a taxi, we know there is at least one independent third-party witness. We need to know who this witness is and what they said to the police. Are they cooperative with the police? Are they cooperative with us? It's important to remember this was reported away from the scene. The police may not, at the point he was arrested, spoken to the taxi driver yet. And if you get there first, you can talk to the taxi driver first. It's a New York taxi. So what percentage of taxis have videotape in 2023? Smart money is most, if not all. So your job as a defense attorney is to not only get to that driver, but get that video. If you can get it before the police, great. But if you need to get it before but you definitely need to get it before the internet or before TMZ in a situation like this where you're trying to save the defendant's public image. At this stage, we don't know if the video is good or bad yet. So our job is to get it first so we can get out in front of it. Generally, when police get what they consider a credible report, what they call a credible report of domestic violence, their first job is not to corroborate it or to validate it. They see their job as to stop the danger, get the accused off the street and into custody. In fact, the report plus the injury to the neck, that's corroboration for them. That means any other evidence that may either corroborate or counteract that report may still be out there. Our job as the defense attorney is to race to find it, to get the full picture before it disappears to time or to changed memory. Finally, that this is reported the morning after tells us two things which may be true. They may not be, but we have to explore this to be conscientious. One, after a night of drinking, the accuser did not call the police. Why? Was she drunk? Was she intoxicated? Was there anything else in her system? Was it a state where her reactions or her ability to perceive or memory would be affected? Is that part of the reason she didn't report it immediately? Did she not want the police to see what kind of state she was in physically as opposed to as a victim of a crime? There may be a witness in the bar or receipt of the alcohol drank. There's fear that the witness in the bar will say your client was violent inside the bar. So again, we want to get out in front of it, but we have to be very careful with that. And I can't tell you how common and important this is. There's probably a list of phone calls or text messages all night. One side or the other probably texted. Why won't you respond? I just want to talk to you. Why would you do that? I'm sorry for what I did. These are all admissible in court. Any text message like that is most likely admissible in court. And I need a list of all of these. And in this case, there are those text messages. I wrote this the day this happened, and I wanted to get my hair cut before I made this video. And like an idiot, I waited to make my hair cut. And in that time, they've published the text messages. So let's go over what those say in a minute. But I can't tell you how common that all-night text is. It's so many of these cases. And that call to the police is because there was no one else to talk to. The accused wouldn't answer the phone. Also, how often the person blocked the number or erased the text, meaning I can't get a copy of those texts until I show up for court to the discovery process. We've seen them where some of the texts are erased, some of the texts are not, and it goes both sides and it goes both ways. We never know what we're going to get when we get there. Let's talk about what the actual charge is, because I think that's very important in this case. Then I'm going to put up the text message, and we'll talk about the text message. So my understanding is that it's strangulation with a bunch of lesser included offenses that may not be 100% correct. But what I want to do is talk about strangulation so we can understand what that means. I do not have a background in New York law, so I'm going to talk about it in my jurisdiction's context. That being said, many of these jurisdictions interpret it either the same or similarly. If I'm wrong on minute details, I wouldn't be surprised, and I want to get out in front of that just to say that. A person is guilty of strangulation in the second degree when he or she commits the crime of criminal obstruction of breathing or blood circulation as defined in this other section of this article, and thereby causes stupor, loss of consciousness for any period of time, or any other physical injury or impairment. Strangulation in the second degree is a Class D felony. So what we want to do is we want to look up the phrase right here is criminal obstruction of breathing or blood circulation. That we have to figure out what that definition is. So we go to the statute 121.11. Person is guilty of criminal obstruction of breathing or blood circulation when, with intent to impede the normal breathing circulation of the blood or another person, he or she A, applies pressure on the throat or neck of such person, or B, blocks the nose of mouth of such person. So what is so what is he accused of? Either applying pressure on the throat, blocking the nose or mouth, probably applying pressure on the throat here, but one of those two, and that the pressure he caused was, let me see. So what the pressure he caused was for the intent to impede her normal breathing. So he choked her not mistakenly, not that his hand slipped, but he do it with the intent to impede normal breathing or circulation of the blood. But then also that action he took caused stupor, loss of consciousness for any period of time, so even a split second, or any other physical injury or impairment. I can't tell you if in New York they consider laceration to the neck that type of physical injury or impairment, but as a layman without the New York background, I would say that would make sense to me on top of the loss of consciousness or stupor. And the penalty for this would be a Class D violent felony. So these charges range from a punishment of 2 to a 7-year prison sentence. That's real scary if that's what he's looking at. So that is the laws. I looked it up in some. It's not the full thing because the full thing is going to take too long, but that's in some. I do want to talk about the text messages that were released. I'm still kicking myself because I knew there were going to be text messages and I predicted it, and then I waited to put the video out to tell you guys this. Anyway, here's the text messages. Let me read it to you because it might be too small here. You can find them anywhere on the internet. These are the ones from him. Do you have the keys and goodbye? I believe that's from him. And then from her side, it says, please let me know you're okay when you get this. They assured me you won't be charged. They said they had to arrest you as protocol. They said they saw the injuries on me and they knew we had a fight. I'm so angry that they did. I'm sorry you're in this position. We'll make sure nothing happens about this. I told them it was my fault for trying to grab your phone. I only just got out of hospital. Just call me when you're out. Text message number 2 is I love you. Keep in mind what police tell the accuser. They're absolutely allowed to lie. They're absolutely allowed to lie to both sides. There's certain things they're not allowed to lie about. This is the type of thing they're absolutely allowed to lie about. Their job is to minimize is the wrong word, de-escalate the situation, move the situation down to make it as easy for them to do their job in making an arrest and keeping people safe, which is what their job is, keeping people safe as possible. to do that, they're allowed to lie to get you to say things, especially as an accuser, which may be against your interests, which may be against the interest of parties which you want to protect, things of that nature. The other part of the text message, they just called again to check on me, and I reiterated how this was not an attack, and they do not have my blessing on any charges being placed. As a side note, they do not need your permission to proceed on charges. The state is absolutely allowed to take the charges and run with them. They generally do need a witness, so it's going to be hard to prosecute him without saying he did XYZ. In this case, though, if it happened at let me get to that last. I read the paper they gave me about strangulation, and I said point blank, this did not occur and should be removed immediately. The judge is definitely going to be told this. Again, the judge may be told this, but it may not be said the way she believes it's going to be relayed to the judge. And that's the fear, right? The classic example is the police officer to the scene says, "Oh my God, you killed that man." And the person responds with, "I killed that man?" And then the cop, as a question, and then the cop says in court, that's when he confessed to me, "I killed that man." A lot of it is about things like that. And this may be one of those times where they're telling her one thing and it may be relayed, maybe even word for word, but it may be relayed the other way. And what really scares me is this next part right here. I'm going to skip just sentence. I also said to tell the judge to know that the origin of the call was to do with me collapsing and passing out, and your worry as my partner due to our communication prior out of care. Here it sounds to me like she's admitting to passing out. Now, that doesn't mean he caused her to pass out. I want to be very clear about that. That's not what it means. But looking at this through the eyes of a prosecutor, you have an injury around the neck. You have her admitting to being passed out, which is either stupor or losing consciousness. You have, I think, in their texting of fighting. This is not a slam dunk victory for him in the sense of if we read these texts, oh my God, it's all a big misunderstanding. He wasn't accused. There's a lot of prosecutors and a lot of people, and I can't doubt them for saying this, who would say what she's doing is protecting him to the detriment of herself. And people would say we have to protect her from him. And that's something I've talked to a lot of people about, where sometimes when you recant, sometimes it's easier to defend a case where the witness is still testifying against you, because the jury can smell that they're angry, they're mad, and they may be lying to hurt you for any number of other reasons. But when they're recanting, sometimes what ends up happening is the jury feels they have to protect the victim from themselves, because otherwise they're going to go talk to or they're going to go right back to the situation they were in. And if they think that's a dangerous situation, they may make a wrong decision because of that, or a wrong legal decision, I should say, wrong legal conclusion because of that. The reason you guys tune into this is because you want to hear my predictions. It's impossible to make predictions in cases like this. Let me actually predict what's going to happen. Even with everything the attorney says, and I hope what they say is true, I don't think it will be dismissed out of hand. Prosecutors aren't equipped to look at a situation like this, throw their hands up and say, there's not a victim. It happens. Cases like that happen, but very rarely. They're handymen who own a hammer as their tool, and the whole world is a nail, and they feel like that's the tool they have to use to fix the world. She has physical injuries. Any resolution of this case has to address how she got those injuries. And the stupor is important, but if she's a laceration to her neck, prosecutors are not going to accept a dismissal of this case that doesn't have an innocent explanation to that laceration. It's not the same as having redness to the arm or somewhere where you would catch someone as they're falling, for example. And no one's accused him of having defensive wounds, for example, in this case. Even if she admits she tried to take the phone first, that doesn't mean he has every right to, for example, choke. He may have a right to push her off, or to turn his back to her so she can't grab his phone. Doesn't mean she has a right to, or he has a right to choke her until she passes out. And if that's the way the prosecutors see the case, he's going to get charged, and they're going to end up taking it pretty far. I don't think the attorney lied in this case in any way. I think she may be interpreting things in her client's best interest to get out in front of them. Sometimes there's two ways to interpret the exact same videotape. That videotape's going to be a lot. I do, to some degree, think that if the videotape acquitted him 100%, you would have seen it by now. To some degree, I don't know, but I don't think that's an unfair assumption to make. That doesn't affect us in court. Let's be clear. That's not admissible in court. But as a court of public opinion, which I seem to be an attorney in, I don't like the fact that we haven't seen it yet, and the attorney has said that she already has it. Although they need to say that we're not publishing it for the purpose of protecting the victim. That's the presentation I think they should take in order, if they are going to say that they're not going to publish it. In a lower profile case, the witness may decide, that being said, Majors does not want to go to trial. He doesn't even want to edge up to trial in this case. He's got to figure out a way to minimize the damage to his career. In a lower profile case, the witness may decide to just not appear in court. That doesn't mean the state can't proceed with the video or the taxi driver witness and the photographs, but it does make the case that much harder. If she were to move out of New York, it would be very hard for them to make her testify, but that's completely up to her at this stage. If that makes the news cycle, that wouldn't provide, the fact that she moved away, that wouldn't provide Majors with the necessary closure he may need for his career. And that's a wrestling match a lot of defendants have. Is, do I want closure? Because sometimes closure is bad. Sometimes closure is, there's a reason I never liked you, and that's why we have to break up. Sometimes in a criminal jury trial, closure is you're going to jail. So it's not always the acquittal people want. Could he plead to something lower, take classes in domestic violence, give a major donation to women's charity? Honestly, in a case like this, I would assume that's the safe prediction. The vast majority of cases go along the route where you take some kind of plea, do probation, do community service. But only he and his attorney can determine if they think that's the safest outcome for him long term. And you never know. Maybe that taxi video shows him strictly defend himself, and the laceration on the neck is from the seatbelt that she's leaning over to attack him. It's hard to predict it. It's hard to see that, but we don't know. So I appreciate you guys sitting here and riding with me through this. If you have any particular questions about either this case, the charges, the information, you want me to look at something else, I have time right now. I'm not working. So maybe I shouldn't announce it. If you guys want me to talk about something else, go ahead and let me know. Or if there's another case you want to see, maybe we should do that. And thank you very much for tuning in always. I really appreciate your time. Thank you. Bye-bye.